Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable United States Court of Appeals for the Fourth Circuit are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court.
You may be seated. Mr. Moravec.
Yes, Your Honor. Good morning.
Good morning. You may proceed.
May it please the Court. My name is Joseph Moravec. My client, Freitas Ortez Reyes, was granted asylum in the United States, but through the misapplication of the wrong statute, USCIS would see him separated from his wife rather than obtain derivative status for her through a petition to USCIS. The case today concerns whether USCIS is permitted to apply the wrong statute when evaluating a discretionary application, and then whether that decision to apply the wrong statute is protected and insulated from this court or any court's review. In effect, USCIS is asking this court for unreviewable statutory interpretation. The court below dismissed because the INA generally bars review of discretionary applications, but it is not within the agency's discretion to apply the wrong statute, and that remains reviewable legal error.
Counsel, how do you understand that argument that what is happening here is a statutory interpretation, which statute applies and how do they relate? But how does that argument survive our decision in Shaban? And in particular, the argument that the petitioner made there, that once you had made a terrorism finding, the ultimate decision was no longer discretionary. It was, and we said, no, Congress has said this is statutorily discretionary.
Sure. So the court in Shaban says, yes, there are these ultimate discretionary decisions, but the court also recognized that its decision in Moore from a few years earlier is still good law. At least in dicta, it said, Moore versus Frazier says, yes, the ultimate discretionary decision is not reviewable. But if the agency is going to apply the wrong statute, it doesn't have the discretion.
But no question, I appreciate the Moore. I want to hear a little more about that. But I'm really talking about there, it seemed like that case had three parts. It kind of interpreted Patel, then it interpreted an argument that the ultimate decision itself, while it could be discretionary, was in this circumstances not discretionary. And we said that doesn't matter. It's not a functional sort of test. It's statutorily discretionary.
Sure.
Would that rationale not apply here?
No, because I think there's three things that really go into an ultimately discretionary decision. The first thing the agency has to do is decide which statute governs the application. The second thing is it has to decide whether the applicant is eligible under that statute. Mm-hmm. And the third thing is they have to weigh all of the discretionary factors. Everybody, including myself, agrees the Supreme Court's precedents, the statute itself, take away the third question, the ultimate discretionary question. Courts are still grappling with that middle question about what happens when you make eligibility determinations. But what we're dealing with here is that initial question, is whether or not the agency is free to read other statutes and say this statute applies. And in this case, whether 8 U.S.C. 1231A5, which has no bearing on derivative asylees, whether they can read that statute in to govern. And that question, that initial question, has nothing to do with discretion, and it is not within the agency's discretion to read in other statutes.
I don't think either you or your colleague made this point, so I may be off base, and if it comes too far out of left field, just say whatever, you can move on. But 1252B9, which is, I think, referred to as the zipper provision, says that any questions of law or fact arising from actions taken to remove or proceedings to remove must be brought in one proceeding. Does that apply to this case? And if not, why not?
No, and I appreciate we could file additional briefs if it becomes an issue for the panel. I'm happy to address it more fully, but I don't think so. And here's why. The question we're ultimately dealing with isn't a decision to remove Mr. Ortez's wife. The question we're deciding is whether or not she's eligible to receive from him a derivative asylee status. And so those are two separate things. The questions that are barred by B9 are really questions related to detention, to the actual putting somebody on a plane and removing them.
I don't think that's right. I think there's Supreme Court case law that says potentially CAT decisions fall within that, which don't affect removal. And the specific language is arising from an action to remove. And why isn't a claim for derivative asylum not arising from the government's action to remove your client?
Well, to be clear, my client, Mr. Ortez, is not removable.
I'm sorry.
That's the
His
distinction
wife.
I think that matters, is he's petitioning for his wife under a provision that doesn't deal with, removability and
I
questions.
got you.
It deals with ultimately the need for family unity. The regulations talk about.
So I got you. I'm sorry to cut you off. So your point is, since there's no removability issue as to him, it doesn't arise from removability. If this was her petition, perhaps it might.
It might be different.
see.
The statute lays out that the petition is in his name. It's his right to confer that benefit. And as the statute says, he may apply for it. There's nothing that says he has to, and there's nothing automatic about bringing that application for her. The other thing is, if B9 is read so broadly to encompass anything that relates that tangentially to removal, it would certainly swallow the rest of 1252, because what we're dealing with here, what the court has said is these discretionary applications and petitions are supposed to be really evaluated under 1252A and A2B, specifically here. And so the naming of the petitions, the naming of that discretionary relief here suggests that B9 isn't where we should be looking for our guidance.
If we're to agree with you on the jurisdictional issue and find that we do have jurisdiction, looking to the merits, reading just the plain text of section 1231A5, it says that it prevents any person with reinstated prior removal orders from receiving any relief under this chapter. Those are the words of the statute. And the section for derivative asylum relief falls within this same chapter. It's 1158B3A. So doesn't that mean that someone who is with a reinstated removal order is ineligible then for derivative asylee status?
Respectfully, no. And on the merits, which my colleague will say we didn't actually get to and didn't have full briefing, on the derivative statute is 1158B3, and the applicable regulation is 8 CFR 208.21, and it lays out the statutory bars. They give 5 bars that say if you fall under one of these 5 statutory bars, then you're not eligible. But the regulations and the statute both make clear that this is only for people who aren't otherwise eligible for asylum. 1158B3 specifically says, may, if not otherwise eligible for asylum.
But the 1231A5 suggests that she's not eligible for any relief under the chapter. Isn't this relief under the chapter?
And our reading out of the plain text is that it doesn't say that she's not eligible for any relief. She's not eligible to apply for any relief. And that's this court's decision in Mejia from several years ago, is that even though the asylum statute says everybody in the United States may apply for asylum, 1231A5 is read to preclude that. She's not eligible to apply. I concede that, and we concede that in our briefing throughout. But she's not the applicant. She's the beneficiary. The question at issue is whether Mr. Ortiz, who's been granted asylum, may apply for her. And the only statutory bars that apply are contained within 1158B, as defined in the regulation, as made clear in the regulation, 208.21, where Section C says it specifically, they may apply, and it says regardless of the status of that spouse in the United States. CIS contemplated that no matter what the status of the beneficiary in the United States, as long as they didn't meet one of those 5 statutory bars, they should be granted derivative status through the spouse. The decision here is that USCIS would like to read in this other statute, 1231A5, which has no basis in the statute. That is an extension of statutory interpretation. And for this court today, that decision goes beyond the discretion of the agency. And so the court should find that there was jurisdiction and reverse the district court as to the jurisdictional question. And either the court can reach the merits, which we can continue addressing, and I'm happy to do, or remand it for us to deal with the merits before the district court. But what's clear today is the agency doesn't have unreviewable statutory interpretation regarding the standards which it is going to apply to evaluate these applications. And so the court has to allow review of its decision to apply the wrong statute. I think what will come up, I think the question for this court ultimately is the language from Patel. And whether or not the court there, closes these other questions as to eligibility, and respectfully it doesn't. And I think that's recognized in Shaiban. It's also recognized in Barfa last year, again by the Supreme Court in a unanimous opinion, that while it did close jurisdiction in that case, the underlying 11th Circuit decision and the court there really lay out that 3 parts that I brought up at the beginning, the 3 parts of analysis, that there is the statutory applicability, then the eligibility questions, and then a discretionary determination. And 2 and 3, 2 we might still waffle about, but the first question, which statute applies, that's under this court's precedent and more as recognized in Shaiban, which, Judge Gregory, you joined that opinion a few years ago. We still recognize more to be good law.
Can I follow up on more? Sounds like you're not contesting Siobhan's decision that B2, that the Patel logic applies to B2 as well as B1. You see where I'm going? That part. That was one of the decisions it made, is that Patel was B1. We think it applies to B2. Doesn't sound like you're really quarreling with that. You're just saying the nature of the decision is more like a Moore decision than a discretionary decision.
Well, I'm certainly not happy with the Supreme Court, which in Patel says, we don't need to decide this issue. We're not going to decide this issue, but here in dicta, we think there might be enough. And so, and then this court in Shaiban says, well, the Supreme Court.
Whether you're happy with the Supreme
I'm not
Court
happy. You're not.
You got to be not only not happy with them, you got to be not happy with us too, right?
Sure. No, but I think this court in Shaiban, the decision, the reason we cited it is it still recognizes the distinction. And in Patel and in Barfa, the Supreme Court says we're not going to reach that issue. Here's what we might think about it. The parties in that case argued about the dangers of foreclosing USCIS decisions from review at all.
One last question about Moore. Wasn't the question in Moore about the authority of the agency to take some sort of action? I mean, I agree with you, it's a legal in nature decision as opposed to the application of facts to law. But our discussion about it in Siobhan seems to talk about, the fact that it's removed from the adjustment of status considerations. So not only, it's not just that it's maybe legal, but it is not part, it's not like a preliminary step, it's not part of the adjustment of status consideration. And that's why it didn't affect the Siobhan decision.
Sure. I want to answer your question, but I'm out of time. Can I
You
answer
may.
the question?
You may.
Okay. The issue in Moore is that there was an adjustment of status based on, and a visa petition based on, that was barred based on the Adam Walsh Act, and that prevented certain people from being eligible if the agency made a discretionary no-risk determination or denied on that basis. The question for the court in Moore was, well, which version? Because that had been amended. And so the question is, which version of the statute applied? And in that case, it was at least the same statute. It's just the question of which version. In this case, the question is, can we read in a completely other statute that doesn't bear on petitions? And so for that reason, I think this case, as the court recognized in Siobhan, it might have been a closer case if we'd had a question of which statute applies. This is that case, respectfully.
Thank you, Mr. Morag.
Thank you.
Mr. Cooper?
Good morning, Your Honors. Christian Cooper, Special Assistant United States Attorney from the U.S. Attorney's Office of the Eastern District of Virginia, Department of Justice. And may it please the Court. The sole issue in this case is whether the district court erred in determining that it lacked subject matter jurisdiction to review USCIS's decision to deny the plaintiff appellant's Form I-730 refugee asylee relative petition, which the plaintiff appellant filed on behalf of his spouse. The Immigration and Nationality Act couldn't be more clear. Decisions that are specified to be in the discretion of the Attorney General or Secretary of Homeland Security and his or her designees are immune from judicial review under 1252A2B2. This court confirmed that approach in Siobhan B. Jadu. And as the Supreme Court recently stated in Buarfa, may clearly connotates discretion, and the INA provides USCIS may grant an alien derivative asylee status pursuant to Section 1158B3. Indeed, whether the plaintiff appellant presents a question of law, a question of fact, or a mixed question of law and fact, the district court properly found that it lacked jurisdiction to review the plaintiff appellant's claims.
Mr. Cooper, your reading and your position, I think, is very clear. So you would say, this is hypothetical, obviously, if a person is applying for derivative status for the spouse and the application is made and they have evidence that the person is married to that person and they stop it right there. No, you're not married. And just ignored the documents that were not disputed and said, no, you're not married. You're not eligible to go any further. You're saying this court would have no jurisdiction to deal with that situation. Is that, I just want to make sure how the extent of your jurisdictional argument is.
From the Supreme Court's reading of
I'm
Patel.
going to ask about the Supreme Court. I'm talking about you, your argument. Is that the logical extent of your argument that if they said, I see the documents, you're married, I don't dispute it, but you're not going to get derivative status? End of story, period. Is it your argument that this court, third branch, judicial body, could not intervene, would have no jurisdiction? Is that right?
From the reading of Patel v. Garland and Shaban, that I believe that would be correct, Your Honor.
What if let's just take this the other direction. What if there was a ruling that expanded the definition of children to include nieces and nephews? Would that also be unreviewable? If there was a niece that somebody said, I want to get derivative asylum for my niece, and derivative asylum was granted for a niece, even though the statute clearly only covers spouses and children, would that also be unreviewable?
To understand your argument, to understand your question, Your Honor, you're asking if the reviewability of whether or not a person is a child would be unreviewable under this statute, correct?
If there was a clearly erroneous interpretation of the statute, would that be unreviewable?
It is the government's position that from the reading of Patel v. Garland and the Shaban case, that any decision, whether it be a factual or legal determination, is immune from judicial review under Section 1252A2B2 for anything that the statute prescribes is in the discretion of the Attorney General or the Secretary of Homeland Security. In this
Your friend
statute,
on the other side divided the decision-making process into 3 stages. What law to apply, whether applying that law to the facts, and then the discretionary application. And conceded that the 3rd step of that is clearly discretionary and unreviewable, but said that this case falls within the 1st step, what law to apply. So it's the government's position that even if we're talking about what law to apply, that determination is also unreviewable?
from the reading under Moore, I think if I can distinguish from what I believe this first step is, as opposed to how my co-counsel brought it, or my opponent counsel brought it forth. So I think what we're getting at is the issue in Moore specifically, and how Moore you were able to view, how the court decided it had jurisdiction to review which specific statute to apply. In Moore, one of the things that Moore specifically held in that Shaban confirmed is that in Moore, it didn't go to the effect as how USCIS was exercising that discretion. And because they weren't challenging how USCIS was exercising discretion, they could review it in Moore. Here, this is a challenge to how the USCIS used its discretion to deny the Form I-730. And I
But
think,
use the discretion by saying, I'm going to read in a different provision, as opposed to saying, I'm going to look at all the facts, and granted, you look at the facts, discretion, we don't think you did. But to just sort of come in and swoop out and say, no, we're going to apply to this, it can't be just full of discretion there. It would make no sense. I mean, right? For example, so then you would say, so they say, we're only going to grant the I-730 to people who are of European origin. You could do that, right? Just say, well, all the other continents and people and whatever, if you don't come from Western Europe, we're not going to grant it, right? We could do nothing. We could just, discretion. Is that discretion too?
I understand your point, Your Honor, but I want to stress that,
I'm making a point. This is a question. Is that right, that they could just do that? Just say, no, we're going to pick that continent. Matter of fact, not the whole continent, but just the Western aspect of Europe, not Southern, and that kind of thing. And we do nothing. We just sit back and say, well, aren't you upending the whole idea of what Congress does? I don't think Congress is meant to be an orderly way. You have the discretion, but you do have to at least get people at the table with the right law and the right idea and the right constitutional context of it. But you're saying, no, you just have a blank slate, tabula rasa, and we could do nothing. That seemed that's what it would just, devolve to, wouldn't it?
respectfully, Your Honor, for that specific hypothetical, I
Yes.
think there's underlying constitutional questions when it comes to that as well, and I am not opined to provide, I have not prepared for such type of question, and I do not know the answer to that question. But I want to stress that.
Well, let me ask you about that, because I had asked your colleague about whether, 1252 has an exception to the unreviewability of certain decisions, including ones that are, fall in that discretionary bucket for questions of law and constitutional questions. And that's kind of why I was trying to figure out, is this a claim that that part of 1252 applies to, for just the good questions that Judge Gregory and Judge Berner are asking? And that seems to perhaps raise the question of whether this is a question of law that falls under 1252B9, the zipper provision, or at least I'm wondering about that. Do you have a position on that?
I do not have a position on whether Section 1252B9 applies in this case, but I do want to specify the the question of law and how questions of law and constitutional claims can be brought in a petition for review in front of the circuit court. So that is in Section 1252A2D. A2D specifically only applies to those who are seeking relief in removal proceedings. This court, and I believe it was Lee or Rowland, has explicitly said that that exception or that ability to raise in the petition to review only applies to those that are in removal proceeding, and it does not apply to Section 1252A2B2.
So that means you believe, your answer has to be there is no provision for constitutional challenges, if the claim is under, I mean, I know you said you weren't prepared to talk about I'm not trying to push you in there you're not prepared to talk about, but seems like that's the implication of what you just said.
Yeah, and I think it's important to note that I believe, I'm going to butcher this name, so I'm sorry, Pofilet v. Cucciolini. In that case, there was a constitutional question that they raised, and the court also found that it did not have jurisdiction to review that constitutional question, and a decision to revoke an I-130 petition pursuant to Section 1252A2B2.
How do you square your position with our decision in Moore? In Moore, we specifically say, we talk about distinctions between discretionary decisions and those that are not discretionary. Even though the statute contains discretionary language, it doesn't mean that every decision under the statute is an exercise of discretion.
Thank you for that question, Your Honor. Specifically, I think one of the big distinguishes from Moore in this case, which Shaban identified, is that the petitioners in Moore were not challenging how the agency is using its discretion or how it's being exercised.
Well, they're not challenging that here either. They're saying the wrong statute was applied. They're saying that the incorrect law was read into the decision. This isn't a challenge of a discretionary determination. It's a challenge of a legal determination, that he was statutorily ineligible to file for derivative asylum on behalf of his wife. That's a legal determination. It's not a question of exercising discretion over this particular individual.
You are correct, Your Honor. I agree that this specific challenge is to a statutory eligibility legal determination. But specifically, Shaban clearly, there was also a legal or statutory eligibility question that was raised, and that was whether or not the applicant at that case was inadmissible. And they found that they were inadmissible.
But isn't that at least a different, I mean, eligibility seems to me to involve determining whether certain factors exist, and in that case applied to the bar against terrorist activity. But it was looking at factors for an individual and whether they qualified for being engaged in terrorist activity. So that seems like more of a mixed question of law or fact. I mean, you've got facts, you're applying them to the law. This doesn't seem to have anything to do with anything but law.
but law. I understand, Your Honor, but I think it's important to note that the underlying bar in Shaban was a legal bar. It was under a legal determination that was made pursuant to 1182. And this is the same case here, where there was an illegal eligibility, where underlying, like you say, if it's a quasi question of fact or law, this could also 1231A5. You would also have to look at the facts to see if that person had a reinstated removal order. And you would have to
The
look.
question here isn't whether they looked at it and applied it correctly. The question is whether it should be applied at all. That's what your colleague on the other side is saying. They're saying that it shouldn't be applied at all because it only applies when the individual applying for relief is statutory ineligible, not their spouse or child. And so the question they're presenting is a question of law, not a mixed question of law and fact. You began by saying that we could not review questions of law either. We are also precluded from reviewing questions of law.
And that is still the government's position in at least this round, and at least when it comes to Section 1252A2B2.
You opened by saying there's only one question presented on appeal, and that's the question of jurisdiction. If we were to disagree with you and find that we do have jurisdiction, could we not then proceed to the merits of the matter?
This court has its discretion to whether or not to proceed on the merits in this matter. If they were, we would ask for additional briefing on the matter and be able to brief that subject specifically, as this appeal was based on only the jurisdictional grounds, and the district court only addressed the jurisdictional grounds in its decision. But ultimately, if the government were to find that, or if this court were to find that jurisdiction existed, the government would request that it would remand it back to the district court as the district court, so that the district court can analyze the underlying facts and legal claims made in the complaint.
So you don't have a position right now that you want to argue on the merits?
No, Your Honor, we would respectfully ask for more briefing on that matter, as it was not addressed in the decision below, which is why we do not think, we don't have the ability to address it here. If the court has no more questions, I think we see.
Thank you, Mr. Cooper.
Thank you.
Thank you. Mr. Moravec, you have some time reserved.
Yes, I just want to make two brief points. One is, my colleague says that the statute 1252A2B2 is clear that all of the decisions of the agency, including, as I understood him, legal challenges, legal questions, are specified to the discretion of the Attorney General or the Secretary of Homeland Security. But that the specified to be within the discretion is the key phrase. This court in Moore went through that analysis that we're asking for here. The government relies on Lee, but Moore contrasts Lee and says, nowhere in the decision is the decision of which version of a statute applies to the adjudication of pending petitions committed to discretion. The agency doesn't have the discretion from that statute, from the jurisdictional statutes. The agency has no discretion to just apply the wrong statute. The other thing is, in going back to the actual underlying USCIS decision, the government says, well, it's just about how the agency applied its discretion. Go back and look at the decision. Well, in the joint appendix at 21, that's the factual analysis of the agency, and it says, you have established your beneficiary is your spouse and that your marriage is both legal and bona fide. To Judge Gregory, your point, your hypothetical is the agency found what it needed to find, that she was eligible, and then applied a totally different statute to otherwise find that she's not, and to deny the application. The reading in of that couldn't be more clear, and under this court's precedence, the agency doesn't have the discretion to read in that statute. The court should reverse the district court's finding that we lack jurisdiction to to consider the misapplication of the statute.
So if playing that out, let's assume you're right, that, the term, use of the other statute to say you're ineligible is something courts have jurisdiction to review. Could the agency say, yeah, you're eligible, but it's a discretionary decision about whether to grant the derivative asylum, and we think, even if it doesn't make you ineligible, that this other statute that the agency relied on could be something it could consider in denying relief?
Yeah, I think in these types of discretionary decisions, there are field manuals for the adjudicators that indicate how they're supposed to weigh certain factors. Those are ultimately discretionary factors and wouldn't be able to be challenged. But those manuals, those guidance documents make clear that just like an application for asylum that this court might see come through a removal proceeding and a petition for review, there's lots of precedent that say asylum denials on discretion are supposed to be exceptionally rare. There's 5 statutory bars that are here. They all relate to terrorism, serious non-political crimes, particularly serious crimes, significant felonies. The denial on the basis of discretion to somebody who's been granted protection in the United States to have their spouse also be with them should also be exceptionally rare, not, on the basis of a whim or the misapplication of a statute. And so, yes, the agency would have the first bite at that apple. If what we ask the district court is vacate this decision and either order them to apply the right statute. The agency could then go back, not apply 1231 as a complete bar, weigh the facts, and then make a decision. That decision ultimately might become unreviewable based on what they decide, but that's not my point today.
So if the consideration of the statute and the policies perhaps arising from the statute may or may not be something that could be taken into account on the decision. Your point, though, is that's the decision that you have to go through, not just stop us at the door.
Sure. USCIS has to get to that point. At some point in the future, they'll likely make a new decision where they might evaluate his history, her history, their marriage, their children who are U.S. citizens, those kinds of factors, and decide.
You would still have to run the gauntlet of discretion.
I certainly would. It's not the end here, and this court and the district court neither has the authority to order CIS to make a particular decision for my client to grant relief, to order them to grant the petition, but the court has the authority to order them to make the decision using the right statute.
All right.
Thank you.
Mr. Cooper. Mr. Morbeck, Mr. Cooper, thank you. Well, we'll come down, greet counsel, and proceed to our next case. Salzman?
Yes. Good morning, Your Honors, and may it please the Court. This case presents the perfect example of when reassignment was the accommodation of last resort and should have been utilized by the employer to accommodate a disabled worker. By the summer of 2016, it was clear that Mr. Jang could not return to the rigorous pest control position that he had occupied for 7 years.
Permanently or temporarily?
By the summer, permanently, Your Honor.
Where's the evidence of that in the record?
The evidence of that in the record, Your Honor, is, there's a good deal of evidence, but the most conclusive is, first of all, in July of 2016, his doctor says light duty
Sure.
or disabled. In August, Mr. Jang texts his supervisor, Blake Hunter, to say, my doctor says I can only return to light duty. In October, the employer's workers' comp attorney writes to Mr. Jang's attorney that Mr. Jang had reached the maximum medical improvement. So by that point, there's no question. In November, Mr. Jang writes to Mr. Hunter and says, again, I'm not hearing anything from the company. I can't return to work in the pest control position. I need light duty. And Mr. Hunter responds, I know nothing about light duty.
Right.
So it's clear that the only way that this employee can be accommodated is through light duty.
Yeah, I'm just trying to think through the timing element. So that your position is the July 16 release from the doctor is evidence that he is permanently unable to do the job he had had for a while?
It's a clear indication that they need to trigger the interactive process. And there's no response whatsoever by the employer to engage in the interactive process. And as time goes by, and it becomes clearer that now we're, by October, we are 8 months out on unpaid leave, and he still can't return. And the employer is saying to his lawyer, you got to talk settlement because he's reached maximum medical improvement. Then absolutely, there needed to be a discussion. There should have been a discussion from July when his doctor says he needs light duty. They had light duty, and nobody engages with Mr. Jang about it. They had 2 opportunities for light duty. The easiest is the customer service representative position, in which an employee from his very branch in June of 2016 had just vacated that role. They say they were centralizing in Fairfax.
But it doesn't, I appreciate your argument on the lack of response or a lack of much response. But I think your client, you mentioned the June situation. There hadn't been a release even for light duty at that point, right?
He hadn't, correct, he had not specifically.
And he hadn't requested himself the assignment to light duty at that June point. The reason I'm sorry, go ahead.
I apologize.
No, you're good. I want to hear your answer.
He hadn't done it in writing yet.
Right.
So his testimony is that he was speaking with Mr. Hunter repeatedly about the option of light duty. But in July, his doctor in writing says it has to be light duty.
Well, his doctor said, I don't want to quibble too much on this. I think there's an issue of whether being released for light duty is a request by him to do that. That's maybe not that big of a deal. But let's assume, I think, that the request for light duty is either July or August when we have evidence of that. And let's assume, I think, the sales job, which is classified as heavy duty and has requirements that the functional capacity test says he can't do, is not available. So we're at the customer service position. I tried to figure that spreadsheet out. I found, and one more thing on the hypothetical. Assume, I think, once his lawyer tells Orkin that he's going to agree to a settlement that's going to include termination, that there's no more reasonable duty to transfer you from that point forward. I know you probably contest all that.
We do.
But just assume those parameters. Within that time frame, I saw 3 customer service jobs. I forget where they were.
Yes,
They weren't in
sir.
his branch. They were 3 places in like maybe October and November. Did I get that factually right?
You got it right, Your Honor. There are, I believe, 3 customer service rep jobs, one in November, one in December, and I believe there's another one in December or early January.
Walton and then Manassas.
So, but the key point, Judge, is that according to them, they were all centralized in Fairfax. So their servicing branches may be in somewhere else in Virginia, but all he needs to do is drive 18 miles to Fairfax,
Didn't they say at the
Virginia.
end of, they were that the testimony was they would be consolidated in Fairfax at the end of the year?
Mr. Hunter said that it was during the summer that happened.
There's a question of fact on that.
Yes.
I got you.
So I do want to say that we do dispute and believe that he could have performed the sales jobs and that should have gone to a jury. But I certainly agree with you that the easier job is the customer service rep job, where they agree that it was light duty.
I'm sorry.
Yep.
Finish your answer. I keep.
No, I'm sorry. Mr. Hunter testified that Mr. Jang, he saw no reason why Mr. Jang could not have qualified for that job. Mr. Hunter says that he elevated the need for accommodation to human resources and to his boss, the regional vice president, and nobody did anything. And that's Tarquinio. That's the problem here. Tarquinio illustrates the problem with Orkin, and I'm sorry, Your Honor, I know you want to.
No, you're good. Keep going.
In Tarquinio, it's the employee who doesn't allow the interactive process to get off the ground. I'm not going to share any medical information. I'm not going to let you talk to my doctors. And that was, in that case, the basis for this court to say there's no obligation by the employer to accommodate because the employee didn't let the interactive process work. This case is the opposite. It's the employer who just is silence. We're not going to engage. You stay home on leave without pay, which is coercive, until you're ready to settle related, but not the same legal claims, and you'll resign. And because an accommodation was available, Tarquinio makes it clear that if the employer is responsible for sabotaging the interactive process and there was a feasible accommodation that was available, that is a violation of the law. And that's the problem with the way Orkin engaged here.
You got, go ahead.
I had a question on the
Yes.
resignation issue, so
Okay.
you should, yeah. So on the question of resignation and termination, your client voluntarily resigned from the company, was compensated at the time of resignation. So why should we then find that he was in fact terminated? He submitted a voluntary resignation.
Judge, it's our view that a jury could find that he was constructively discharged by June because the way that the company had not engaged, had just simply ignored him by that point for a year. He's not being paid. He's not hearing anything about how he could get back to work, and he has no work. So it's our view that a jury could find that he was discharged. But if a jury doesn't find that he was discharged by June, we still have a denied accommodation claim that expands over essentially a year from the summer of 2016 until June of 2017 that is still viable. It's just a question of relief, which is exactly how Orkin saw it in their discovery responses, which is if he voluntarily resigned, then there's a cutoff on the back pay that he could obtain in the case. If he was constructively discharged, then full relief is at least in play.
And would you please respond to Judge Quattlebaum's question about the impact of the settlement negotiations and whether the obligation to accommodate effectively ended at the time there was an indication that the parties were engaging in settlement?
We dispute that for two reasons, Judge. One is factual and one is legal. First of all, we think the idea that the settlement discussions were part of the accommodation process, that leave without pay was part of the accommodation process, is disputed. Mr. Jang, his attorney in August 16th, writes back to the workers' comp lawyer saying he's not interested in settlement. It's not until January, another several months, where he's being told, yeah, you're at maximum medical improvement, but we're not going to talk light duty. It's just talking about settlement.
Well, is he
that he
actually
says
told
he's,
we're not going to talk light duty, or is he simply not told anything?
I'm sorry, Your Honor, that's correct. He's not told anything. He is told by Mr. Hunter in November, I don't know anything about light duty. That's in writing. But that's all that he's getting.
But he's not told there's no light duty available.
Correct. Well, he is by Mr. Hunter. But Mr. Hunter says that, I told him there's no light duty available from me, but I also talked to HR, and I never heard back from HR. But Mr. Jang's not hearing any of that. He's just at home with the bills piling up and hearing nothing about coming back to work. So it's our view that even when his lawyer says he's willing to entertain settlement discussions, that's not a deal. And it's also not a deal in January when they reach an agreement on money, but the employer is saying he's got to sign a general release, and he doesn't ever sign a general release. And then in March, he goes to the EEOC and he specifically files his denied accommodation claim, which should have been a clear indication to them that he's not through the workers' comp discussions contemplating resolving his denied accommodation claim.
But can I follow up on that?
Yes, of course.
So, I hear your point about October, saying I'm going to engage in settlement, who knows where it'll go, right? That I can appreciate there's a question of fact in October. But in January, the lawyer, I know the client ultimately doesn't sign the documents, but there's a clear miscommunication between the lawyer and, it seems that way to me, because the lawyer says, we got a deal. And he doesn't say we got a deal on money only. We got a deal, and the deal included the release and the termination. And that's, Orkin, it seems to me, should be able to reasonably rely on someone's agent at that point that they have a deal. Now, that doesn't mean we could sue for breach of settlement agreement, but it seems to me you're saying it's unreasonable for Orkin, once they've been told by your client's lawyer that he's going to agree to terminate his employment, that they should send him somewhere else and start working. That seems unreasonable to me.
I understand that, Your Honor, and I appreciate that. I think the problem and the difference is they're not talking about resolving his denied accommodation ADA claims. They're talking about resolving his workers' comp claims. And he is not told, and they don't say in January he's got to resign, that their testimony is, well, Tedesco knew that generally that means that the employee will resign. But he's saying, I need a general release, and it's clear, I think you're right, it's not clear in the record, but I think you're right, there was obviously something going on where Mr. Jang was saying, I want to pursue my ADA claims. He goes to the Maryland Commission and says, before he submits his resignation, he goes to the Maryland Commission and says, if I agree to this workers' comp settlement, is it going to tank my ADA claims? And he's told no. So he is operating under the belief that he's settling only his workers' comp claims. But the legal problem, and all of that was related to the factual problem, and I know I'm out of time, Your Honor, but I will wrap this up. The legal problem is the idea that it is in any way accommodating an employee to start talking about settlement discussions about a monetary claim and leave the guy on unpaid leave at home, which, as I said earlier, is very coercive, is a very dangerous notion under the ADA. Because if that is adopted as permissible, an employer can always say, well, we're, in our discretion, electing to put you on leave without pay, and then let's talk settlement. At some point, an employee is going to be willing to talk settlement.
Sure, I hear you. I think that's a fair point, but I just want to go back to what I was asking about a second ago. We have law about reassignment and how that's like, it's available, but it's disfavored, and,
Yes.
a form of accommodation that, as you said in your opening statement, is is kind of a rare situation. It seems to me there is a different question of saying, okay, we're going to engage in settlement discussion, and therefore we have no more obligation to accommodate, and saying, and the parties reaching an agreement, that we have a settlement. At that point, and again, the fact that your client may not have been on board with what his lawyer says, Orkin had every reason to believe his lawyer, I think.
I think even looking at it that way, Your Honor, and I understand the conundrum that the employer might be in, but before that point, they could have accommodated him.
Right, I understand that.
Before that point, they could have engaged in the interactive process.
I understand that.
I understand that I've gone over my time, Your Honor. If I could reserve just a few minutes for rebuttal.
You may, yeah. Mr. Crestline?
Thank you, Your Honor. May it please the court, and good morning. My name is Charles Crestline. I'm with Jackson Lewis, here on behalf of the appellee, Orkin. Going through the appellant's position, there's a lot is said, especially in their brief, about what they feel Orkin could have and should have done. That's not really the issue before this court. The issue before this court is what Orkin actually did reasonable under the facts and circumstances of this particular case? And the district court absolutely held that it absolutely was reasonable under these circumstances. And first of all, let me clarify from, as Your Honor acknowledged before, from the time that Mr. Jiang suffered his injury in February, certainly until July or August, he was deemed completely unable to work. And so there was really nothing for Orkin to do during that window. This is one of the reasons why I took offense to the assertions in the appellant's briefs that they just kind of put him out to pasture for 17 months. No, it wasn't 17 months. It was a few months, and the first 5 or 6 months, he was deemed totally unable to work, and there was really nothing more that they could do. And then the last 5 months is when they had an agreement in principle reached on the settlement, when they absolutely weren't going to do anything, and
Did they really have an agreement in principle? It strikes me that's a question of fact that should go to a jury.
They absolutely had an agreement in principle, Your Honor.
What does that mean to have an agreement in principle on settlement? Settlement negotiations are certainly not an agreement in principle. It's an agreement to talk.
Yes, but as of January the 3rd, they had agreed on all material
And
terms.
at what point was the employer told that the plaintiff was interested in light-duty work? Was that in July?
It was in July or August.
So what happened between July and January?
Well,
Wasn't there at that point an obligation to engage in an interactive process?
They did engage in the interactive process,
How
Your
did
Honor.
he do so?
Mr. Dieng spoke with his manager.
And his manager said, I don't know anything, you've got to talk to HR. And he said, I'd like to talk to HR, and HR never reached out.
Well, that was later. That was the email that you are referring to now was in November. But there was a dialogue that began in the summer of 2016. He came to his manager, and he presented his light duty slip. And his light duty slip is pretty clear about what the restrictions are. And they are very restrictive. I mean, 20-pound lifting restriction, no,
Do sales reps need to lift more than 20 pounds?
yes, they do. They do. It's in the job description that they have to lift more than 20 pounds, and they have to lift, I think it was up to 60 pounds, sometimes. And there's also a lot of repetitive bending, stooping. It's really has the same level of restrictions as the pest control technicians. I know that Mr. Dieng disagreed with that. He believed that it was less restrictive, but the job description confirms that no, it was very restrictive. There's a lot of deposition and affidavit testimony that it is extremely restrictive. This is not, that is not.
Wasn't there a pregnant employee that was placed on a temporary assignment as a accommodation to her request for an accommodation? And wasn't that the position she was placed in?
Earlier in the year, yes, there was a short-term pregnancy accommodation where they were able to put that person temporarily in a customer service position for a little while. But by the
Doesn't
time,
that create a genuine issue of material fact as to whether that accommodation was reasonable under the circumstances?
it does not, Your Honor, and because by the time, well, first of all, by the time Mr. Dieng was released to return to light duty, that position was no longer, it was no longer in the branch. It had been moved to a central call center in Fairfax, Virginia. And so there was no, when Mr. Dieng presented himself for light duty, it was discussed with his manager. The manager did discuss it with HR. The manager did discuss it with his regional director.
So you're suggesting the interactive process is a process that happens internally in the company and not between the worker and the company?
It happens between the employee and employer, but that doesn't negate the fact that the employer can't do some, figuring out, can't do some.
Well, you should do some figuring out. The question that Judge Byrne asked you is that, should that figuring out also engage the employee? That's the question.
Yes, and they did engage the employee.
But on this record, it said, went to the person and said, well, I reported to them, but I haven't heard from them either. I mean, that's the record. Your argument doesn't really mirror what the record is in terms of any kind of engagement and accommodation. And I noticed you slid very quickly to this, when you had the light duty work for the employee who was pregnant, I assume that you still have the weight requirements there, 60 pounds? She had to lift up to 60 pounds, or there was?
No, the 60-pound restriction was in the sales representative position.
But the position but there was a light duty position that's, at that point at least, didn't require that kind of lifting, right?
Correct. At that time, there was a customer service position in the branch, and
Well,
that.
what's the authority that it has to be at the branch? I mean, it seems to me, I understand your argument that you engaged in an interactive process. Let's assume we think at least there's a question of fact about that. I know you're not conceding that. But if there's a question of fact about that, it seems like the way for you to prevail, you have to, it has to be, the unpaid leave has to be a sufficient accommodation. And I think you claim that it is, right?
Absolutely.
And certainly Hannah, gives you some support there. But it only gives you some, it seems, your colleague says there's a question of fact about whether or not the plaintiff was going to be able at least a question of fact about whether he was permanently disabled from the heavy-duty job. And he cited a few things. You heard it a second ago. What's your position on that?
Well, most of the things that he cited do not support that proposition at all. What he cited was some emails and the July light duty slip, the initial one that said he is released to return light duty. It said absolutely nothing about permanency. And in fact, there's undisputed evidence in the record that both the employer and Mr. Dieng believed that he was going to be able to return to work.
The question is not whether there's evidence in the record of that. We don't have a defense verdict. The question is whether all the evidence says that. And that's what I'm trying to get at. Yeah, I think if there's no genuine issue material fact about whether he was permanently unable to do the heavy-duty job, Hannah's a real good case for you. But he's saying there's a question of fact over there, and he listed the lawyer saying he's at maximum medical improvement. He lists the light duty release. It seems like that doesn't really create a question of fact to me. But the maximum, medical improvement sounds, from Orkin's representative, sounds kind of compelling.
That email was sent months later in October.
Okay.
So certainly for the period of time up until then, it is undisputed that the parties believed and had every reason to believe that he was going to be able to return to his job. And that's why they just extended his leave in order to give him the time that he needed to recover, to seek treatment. In October...
But once an individual indicates that they are permanently disabled and unable to return to their job without, even with any accommodation, it seems to me that your argument that it's a reasonable accommodation to place an employee in what is essentially indefinite unpaid leave places the employee in some kind of purgatory where they can never get out. I mean, it's...
Well, Hannah held that, yes, it was
Hannah was a situation of an individual where the disability was temporary and the leave was given to give the employee an opportunity to recover sufficiently to return to their original position, which is the preferred accommodation. Reassignment is an accommodation, is not the preferred accommodation. But here it was clear that the individual could not return to his job. He was asking for a reassignment of light duty, and rather than that being the accommodation allegedly that was found to be reasonable by the district court was unpaid leave.
Your Honor, the first indication in the record that it might be that he had reached maximum medical improvement was that October 2016 email. So certainly up until that time.
What about July?
There was nothing in July except the light duty slip from the doctor, which said nothing about permanency.
I think, if I could follow up, if I understand Judge Berner, she's asking, okay, even if you are expecting him to come back and he's not able to in his own unpaid leave, if he requests light duty, do you not have a legal obligation to explore that? In other words, even if you're thinking, even if we don't even have the stuff in October, you're thinking he's going to come back at some point, but he's not been released to his job. And in the meantime, he wants to get paid. He's got bills to pay. I mean, do you not have an obligation to at least explore the light duty request?
They did explore the light duty
Okay,
request.
that's not my question.
Right.
Do you have an obligation to explore it?
There is an obligation to explore it,
Okay,
yes.
all right. So then, and so you're, and I know you have your position that y'all engaged in interactive process, but I mean, there are positions, customer service positions, that were filled between between August when he asked for light duty, there's documentation he asked for a light duty job then, and when he's, and let's say January, when he agrees agrees to a settlement according to you. I mean, at least during that point, there's 3 customer service positions. Why don't we at least have a question of fact about that?
I do not believe that there is evidence in the record that there was.
At JA 920, there's a text message between the plaintiff and the Gaithersburg branch manager for Orkin, and the text message says, "The doctor said that I can only do light duty work from now on. You told me that once there was no light duty position available for me. Is this still the same?" August 18th, 2016.
Well, from now on, I do not believe that was an indication that this was medical evidence of a permanent restriction. And I also do not believe that there's any evidence in the record that there were any openings at that time. But even if there were, again.
There's evidence that you filled customer service positions later on in the year before January. I listed 3, and I talked about it with your colleague, and he confirmed that. I mean, do you deny that 3 customer service positions were filled after August of 2016 and before the settlement was reached?
I believe they were all in the November timeframe, the ones that you're talking about.
Okay.
So they wouldn't have been in this time period.
He's still requesting, he's requesting light duty later on, after August. He didn't stop requesting it.
Well, light duty request normally, when an employee, has a doctor's note, says, I'm requesting light duty. It's usually the interactive process is trying to return that employee to his job, with certain light duty restrictions. We're going to take his job responsibilities and cut out the most strenuous things or restructure some stuff so that he can still be productive. The context in which light duty is being discussed by the appellant, and now is that, we're not really talking about light duty restrictions to enable him to return to his job, because even the appellant conceded that was impossible. The essential functions of
Right,
his
he
job.
wants reassignment.
He wants reassignment, right, but at least, at that time, it was, the evidence was that, the undisputed evidence was that the parties believed that he was going to be able to return to work.
But he's telling you he wants reassignment. And I asked you a second ago, assume he thinks he's going to be well enough to do the job he had done for a number of years at some point. But in the meantime, he wants reassignment, so he's getting paid. I don't understand, and you told me you have an obligation to explore that, and so that seems like that's a lot of the things that lead us close to a question of fact, at least between August and January. And you say you filled, 3, and I think the record shows you filled 3 light-duty customer service positions later on in the year, so at least at some point, those became available. Maybe he was a horrible fit. Maybe it doesn't make any sense at all, but, we don't know anything about that.
Well, the fit is relevant to this.
But that's not your defense, is it?
Well, yes, it is in part, because this goes to the, reassignment as an accommodation of last resort issue. And one of the reasons why reassignment is so disfavored in the courts.
You're reading reassignment out of the law altogether.
No, I'm not.
Under your facts, you're saying the interactive process doesn't apply in the situation of reassignment. It only applies when we try to accommodate an individual into their current position. The district court never got to the question of whether he could actually do those jobs. Even though there was evidence in the record that the positions were available, he identified the positions as it's his burden to do, and there was not a discussion about whether or not he was the right fit. That may come out in the jury trial. It may come out on remand, but the record below has questions of fact as to whether or not there was even any engagement in the interactive process.
Your Honor, during the period of time in which it was believed by both sides that he was going to be able to return to work with some additional leave, it was reasonable for the employer to grant continued leave in order to allow him to do that.
But that's a position, and you can stick to that. But I thought, when I raised that earlier and then followed up and said, if that, assuming those facts, that they continued to believe he was coming back to work, he makes a request for reassignment because he'd like to get paid. And you said, I thought you conceded that there's a duty to at least explore that.
I said there was a duty to explore light duty, but
Right.
I didn't say that there was a duty to explore reassigning him to another job. And as long as, the employer had an accommodation in place, which was the leave, and there was a belief that he was going to return to work, that was reasonable. It was reasonable for them to do that. Now, at the time, in October, which was the first indication in the record that he had reached maximum medical improvement, and at that point, Orkin's lawyer reached out to Mr. Dieng's lawyer and said, look, he's at maximum medical improvement, why don't you make a settlement offer? And he did. And at that point, the parties were engaged in settlement discussions, and even though they hadn't reached a final number and didn't for a number more weeks.
You're asking us to find, as a matter of law, that an offer of settlement extinguishes the employer's right to engage in the interactive process under the ADA?
What I'm saying is that it was reasonable under these facts and circumstances when the
We're
employees.
summary judgment, there's not, as Judge Quattlebaum pointed out, a defense verdict. So you're asking us to find as a matter of law. that
Yes.
that once there's an offer of settlement by an employer, the employer's obligation to engage in the interactive process under the ADA ceases.
Your Honor, it was more than just an offer. It was both parties agreeing to go down the path of settlement. At this point, he had been out on leave for more than a
Both parties
year.
agreeing to go down the path of settlement is less than an offer. That's just an agreement to talk. It's
Well-
not even an agreement on principle of what the terms of the agreement would be.
Yes, but at that point, it is incumbent upon the parties, certainly at this juncture, that if they're going to engage in settlement, at this point, the decision was effectively reached, we're going to settle this case. We still got to hammer out a number, but we're going to settle this case. And they hammered out a number soon
Is
thereafter.
it true that you settled a workers' comp case?
I'm sorry?
The workers' comp claim, was that settled?
Yes, it was.
Well, wouldn't he be entitled to those benefits apart from any of this accommodation at all, anyway?
I'm sorry.
Wouldn't he be entitled to some benefit and settlement in terms of the workers' comp separate from this question here before us?
He
Answer that question, if you would. Wouldn't he?
well, Orkin made it clear that this had to be.
I know what Orkin said, make
A
it clear,
global
it was
settlement.
very clear what they were saying or not saying. But the question is, from a legal standpoint, you could be fired and still have workers' compensation claim, couldn't you?
You could.
Right, so, but you put it all together, one ball of wax, didn't you?
Yes.
And in the meantime, he's not paid at all for a whole 17 months. But of course, if we just focus on the 5 months of pay, so like you're in a sweat box, like, okay, well, you're not being paid, you got a workers' comp case, well, it's a chance to kind of like put it all in one ball of wax and get rid of this. That seems like almost,
Your Honor,
that's more than adhesion, that's almost
he
like.
could have said no. Even at that point,
He
he could have said,
I know,
no,
but
we're
it's
not.
excuse me.
Sorry.
He could have said no, but people have to feed their families. It's hard to say no, isn't it? You have to eat, you have to live somewhere. Or you could have said that, well, you could have bivouacked somewhere in the meantime and held out. No, that's stress, isn't it? On anybody.
I understand that his circumstances were tough on him. But that's why they gave him $50,000 in order to, allow him to transition to something else.
All right, unless there are further questions. Thank you so much.
Thank you.
Mr. Kessler. Salzman, everything further?
Just very briefly, Your Honor, Mr. Kresslein said that the company did engage in the interactive process. We took the 30B6 deposition of a company representative with respect to this issue who was asked at Joint Appendix 828, did anyone at Orkin perform a search for vacant positions that Mr. Dang could qualify for in 2016 or 2017 after he was injured? Answer, I'm not able to answer that. Did you ask anybody before today? I did not. Question at 829. Did Orkin engage in the interactive process with Mr. Jang or any representative on his behalf? Answer, I'm not able to answer that question. Did you ask anyone or make any effort to find out before today? I did not. There was no interactive process here.
And those are 30B6 witnesses, right?
30B6.
Counsel, can I, you
No,
have something
just
else
done
you
with
wanted to
that one.
make?
No.
Okay,
Thank
I
you.
just have a question on a separate issue, but
Yes.
if you had another rebuttal point, I want to let you get your points
It was
in.
just to say that Hannah is very different. In Hannah, the company met with the plaintiff and told him, there are no vacant light-duty positions, but if any become available during the period that you're on unpaid leave, we'll consider you for them. That's very different.
The facts
than
are
the situation.
different, for sure, but if you look at the law, because that's where I was going. I
Yes,
was
sir.
trying to, kind of discuss that a little bit. I hear you that the facts there are different. There's more engagement, what they were trying, the accommodation that was requested was something that was not really feasible with the type of job at issue. But what we said was that unpaid leave is a acceptable accommodation under the ADA. And then you combine that with our cases on reassignment, which say reassignment is almost the last resort, which may mean last behind unpaid leave. Maybe you disagree with that. And you combine that with the fact that the employer gets to pick among reasonable accommodations. I think Hannah is factually different, but its legal principle is kind of tough for you. And now you got the issue that maybe they knew he was never going to come back, and that might be a way out of Hannah. But I'm not so sure just talking about the factual differences in Hannah overcome the rule and the implications of it.
I appreciate that, Your Honor, and here's what I would say about unpaid leave. I think that this court has said that unpaid leave can be a reasonable accommodation in appropriate circumstances. And the appropriate circumstances...
Is that what Hannah said?
Well, it's what Kaufman versus Wilson, Kaufman and Wilson versus Dollar General say,
Okay.
which dealt directly with unpaid leave as an accommodation.
Okay, thank
And the point that the court made is when it's a definitive period of time and it's a short period of time, and there is medical evidence that creates optimism that the person is soon going to be able to return to the job that everybody wants them in, the original job, which is why reassignment is an accommodation of last resort. We do not quarrel with that.
Good.
In those circumstances, leave without pay can be a reasonable accommodation. And we believe that in Hannah, it's exemplified that it's that because they're meeting, they're talking, and they have reason to believe that he will come back. He did come back within a short period of time, and he was able to resume his work. Their argument is, well, even Mr. Jang says that he thought he'd be able to come back. They're placing a lot of emphasis on that. And if you read that testimony, it's pretty murky. They're asking him first about 2015, when his second injury, and then right after 2016, well, did you think it was permanent? And he says, well, I hoped I'd be able to come back, and I'll follow the advice of my doctor. That's very different than by November or December or October, him saying, no, I still want to come back. There wasn't any interaction at all, and that's the problem.
One last thing for me, at least. There's been a lot of discussion about the interactive process, and I think I understand where it fits in, but I want to make sure. I mean, if legally a reasonable accommodation were offered, whether or not there was an interactive process wouldn't matter, right?
I'm sorry,
Yeah, assume that Orkin has offered a reasonable accommodation.
Yes.
Just, another case, another
Yes.
reasonable, whatever.
Yes.
Whether they engaged in an interactive process becomes beside the point.
I think that's right.
Okay.
I think that's right. Just to conclude, Your Honors, the whole purpose of this statute is to try to get disabled workers in the economy, being productive members of society, earning a paycheck. This man had 7 mouths to feed. He was 3 months behind in his rent. He couldn't pay his water bills, and no one is talking to him. That was not reasonable. It was error for the district court to say, as a matter of law, that that was good enough.
Thank you, Mr. Salzman. Mr. Crestline as well.
I'm okay, but I'm glad to take a break.
Well, the court's going to take a short recess, and we'll come down and greet counsel.
This honorable court will take a brief recess. judges of the United States Court of Appeals for the Fourth Circuit.
May be seated. Ms. Toma?
Good morning, Judge Gregory and Your Honors. May it please the Court. Jenny Toma for Bashim Jones. I'd like to begin with the argument made by Mr. Jones' prior counsel that his Pennsylvania convictions are not controlled substance offenses under the guidelines. As the government correctly pointed out in their supplemental authorities letter, that argument is now foreclosed by Suncar. And so the most we can do is just preserve that for further review. So that's no longer at issue.
Thank you, counsel.
You're welcome.
Does that, just to clear do a little more table setting, does that also render kind of beside the point or moot the challenges, forget which ones right now, but I think the,
Enhancements.
yeah, the two enhancements, because they can, based on the law, you can get to 29 based on that.
I think the base offense level was capped at 29. And so there are, of all the issues that his prior counsel put in the opening brief, the two enhancements were the two I thought warranted some further discussion, and I'm prepared to discuss those today. I don't, even if mathematically it didn't change the base offense level, I still think that it is relevant to whether or not the district court, correctly procedurally calculated the guideline range correctly, and whether the sentence was procedurally reasonable. Because even if it didn't have the effect of raising the base offense level, if that were true, the district court still knows when it's going through and doing these calculations that these are things that would have bumped him up. It has that in its mind, and it's still, enhancing, it's applying these, and it's coming to a decision with all of these things in mind that it thinks are supposed to apply, even if it doesn't actually increase the base offense level. And so I do think it's absolutely relevant, and I do think two of them were wrong and incorrect, and I would welcome the opportunity to explain that to the court this morning. So I do want to talk about the 4-level enhancement for the altered serial number, as well as the 4-level enhancement for trafficking guns. And beginning with the trafficking argument, Mr. Jones doesn't meet any of the recipient prong criteria for 4 reasons. He doesn't meet it first because there's no evidence in this record that I could find that he transferred 2 or more firearms to any one individual. And I think that's true. The district court could only rely on this single transaction that they discussed at the end of September.
Are you referring to, in the 2 or more and to an individual, is the commentary?
Yes, the note, then note 13, yes.
Why do we get there? Why is trafficking firearms ambiguous?
It's the 2K2.1B5 says if the defendant engaged in the trafficking of firearms increased by 4 levels. And the
Right.
commentary goes on to explain what they mean by trafficking and when that enhancement is supposed to apply.
Maybe I didn't ask a good question. Do we look at the commentary if the guidelines themselves are unambiguous? Can't we just look at the plain meaning of those words without the commentary unless they're ambiguous?
That is, I believe, correct. However, I don't think that trafficking itself without the definition is, I don't think that that's
Well, the way the
unambiguous.
commentary would read was that if someone illegally acquired and sold 20,000 firearms to 20,000 people, they're not engaged in the trafficking of firearms, right?
That's, the way that it read is that it's meant to apply to what are called bulk transfers. So yes, that would be a correct example. 2 to 1 would also be a correct example.
And, yeah, the way the interpretive tools work, if we think that's an unreasonable interpretation of trafficking firearms, we wouldn't look to it, right?
That's true, although I would also say that there's nowhere in these briefs did either of the then counsels get into deference or anything like that. And I think that if the court is looking hard at, deference principles, I think that I would request supplemental briefing opportunity for that because none of that is in these briefs. However.
What about selling, what about the evidence in the record that he sold $16,000 worth of firearms to a few individuals in a hotel room?
Right. That is all that the government and the district court relied on, and I submit that that instance is actually not enough. That is insufficient to find that he or they transferred multiple guns to one person. And I'll point the court to JA, 379, where Mr. Woodard testified, quote, "We met some guys there and gave them the guns." And so these are multiple buyers, and I don't think that's enough for anyone to conclude that Mr. Jones gave 2 guns to one person.
$16,000?
What, I'm sorry?
$16,000 worth?
My point is that there are multiple sellers and multiple buyers, and I don't think there's any way to connect whether multiples went to any one person from Mr. Jones, or indeed from any of them. It could have been one-to-ones, it could have been, it doesn't really say. This evidence just isn't sufficient to draw that conclusion as a factual matter. That was, again, what the district court, all it could rely on too. That's at JA 1230. And so under both Henry and Daniels, that just falls short because, for example, in Daniels, there was district court testimony in the record that Daniels there was a transfer of 2 firearms to one individual person. They actually had that clear testimony, and it was still vacated and remanded for the district court to reconsider under the correct definition whether or not it should apply. And that's far more than what we have here. What we have here is factually ambiguous. It just says that there were multiple sellers, multiple buyers, several guns changed hands, 16,000 worth. I believe that I don't know what the going rate is, but there's admittedly several guns involved in that transaction. But we simply do not have enough information. That's the problem with that instance at the end of September. And the point of that trafficking, the reason why that is best read that way is to give independent meaning to the enhancement. Because as the First Circuit correctly points out, the point is that if it were simply an enhancement for trafficking in multiple guns or for selling multiple guns, that's already accounted for in the original offense level. There would be no need to create a second provision that does exactly the same thing as the original.
It'd be like a double.
Well, the point is not, double counting is permissible, but the point is that as a matter of statutory interpretation, it is best principles to give each provision its independent meaning and effect, and to do that wouldn't be. And so the First Circuit, I think, is very correct in saying so. And those are persuasive, and we think the court should adopt those here. And I would also note, just another factual matter, that at JA 661, I believe that's Bosnack, pointed out that each trace report that they have for those recovered weapons identifies who it's recovered from. And so presumably if there was any evidence that 2 guns were recovered from one person, it would have been presented in this case, and it hasn't been. So we just wanted to add that with respect to the trafficking. I'm happy to answer further questions on that. Otherwise, I'd like to talk about the altered serial number. At the time of Mr. Jones' sentencing, Harris required the district court to apply a 4-level sentencing enhancement for the serial number that was altered but very much still legible and able to be read. After his sentencing, but before briefing in this appeal, the Sentencing Commission promulgated Amendment 828, in which it made clear that Harris was incorrect. And it should have been clear in 2013 when Harris was decided. And the reason that the Sentencing Commission came out that way is because it pointed back to statements that it made in 2006, many years before, where it said, in 2006, we talked about the difficulty of tracing firearms, and that was kind of the basis for what's going on here, is we want to have an enhancement for defendants who make it hard to trace firearms or make it difficult or impossible for us to trace these firearms. And so to state the obvious, there is no difficulty in tracing a firearm whose serial number is very much still readable, even if it's been scratched a little bit, even if it's slightly harder to read, but if it's visible to the naked eye, that is just not a concern. It's not in the spirit of what the commission was trying to do.
But the commission concluded that change would not be retroactive, isn't that right?
I actually don't believe they ever voted on that one. I did look at some of the voting that took place later in the year, and it seems like they voted on 2 other amendments, but at least to the extent that I could find from their meeting minutes, I don't believe there was a vote on it. However, It wasn't made retroactive, but we also think that's beside the point because the lack of retroactivity is not what's requiring this enhancement to be applied to Mr. Jones. Harris is what's requiring it. If Harris didn't exist, this court would be free to, interpret the guideline for him any way it wanted to or felt appropriate. And I'd also add that whether or not an amendment is listed in 1B 1.10 for, retroactive sentence reduction 3582 motions is also kind of beside the point here because Mr. Jones is here on direct appeal. He's never filed a sentence reduction motion. And so what we're talking about is in order for an amendment to be applied in this specific posture while the sentence is still on review and is not yet final. So that's a little bit distinct from retroactivity in 1B 1.10. So, I do think that the supplemental authorities letter that we filed recently brought Whitley to the court's attention, which was a case in which it was the same kind of a posture. Somebody was here on direct appeal and was asked at oral argument, doesn't this amendment undermine this case that is precedential? And it wasn't considered in that case because it hadn't been raised in the brief. But here it was on page 39 of the opening brief. Amendment 828 was explicitly brought up and was raised for the court's attention. So I know that the prior panel rule is usually pretty ironclad, but I think you have a situation here where the legal framework has changed. And so I think that you may be able to revisit Harris, and of course, if the panel concludes that it can't, then certainly the en banc court could. But that is what I wanted to add that was not in the brief.
And counsel, kind of back to the first point you acknowledged with the is it Sunkar case. It sounds like your argument is that even if we agree with you on these 2 points, it's not harmless because the district court had the potential applicability of these enhancements in its head and it was somehow part of the sentencing process?
Yeah, I don't think you can expect the district court to just forget that there's an extra 8 points out there that aren't in this calculus when it's imposing a sentence. And of course, I mean, there is one or two other things that I would take issue with. I mean, at one point, the district court, in terms of justifying its sentence, did say that Mr. Jones had recruited some individuals who he didn't think would have broken the law but for his recruitment. But in the same breath, the district court also acknowledged that those folks were addicts and they were my point is by definition already violating 841 and 846 and probably several other things. And so I don't disagree that maybe perhaps they wouldn't have been involved in the drug trafficking or the gun trafficking conspiracy. But to say that these were law-abiding, upstanding citizens was factually not correct. The second thing is that I looked in the record for anywhere where the district court said, and if I've calculated the guidelines incorrectly, this is still the sentence I would impose under the 3553. I didn't find anything like that. And I didn't find anything of that nature. I didn't find any realization that perhaps these enhancements really shouldn't apply. I mean, the district court seemed convinced that they did. It just, in his mind, didn't affect the math for the base offense level. So that is the most I can really say about that, but I'm happy to answer further questions if the court has them. Otherwise, I will reserve the remainder of my time for rebuttal.
I just want to be clear, do you concede that Harris would foreclose your argument? I know you talked about, of course, the panel, and
Sure.
that's more than just a tradition, that's actually what
Sure.
they guided by. Do you concede that foreclose your argument on that?
It would. If it would be binding on this panel unless you viewed the amendment as something that undermined it sufficiently that you could reconsider it, yes. Thank you.
Thank you. Ms. Shamblin?
Good morning, Your Honors, and may it please the Court. Leslie Shamblin on behalf of the United States in this case. I'll start with addressing the issues that Mr. Jones's counsel just mentioned, and I'll start out by saying that the district court correctly calculated Mr. Jones's guidelines in this case. Turning first to the issue about the application of the obliterated serial number, the district court in this case correctly applied the law at the time that Mr. Jones was sentenced. At the time, Harris was controlling. The guideline had not been amended yet. And as Judge Berner pointed out, it's not one of the retroactive amendments that is listed in 1B1.10. So even if it's something that, if the case were remanded for another reason, could be fixed because of the posture of this case being direct appeal, it's not something that is a legal error that was committed by the district court. The district court, again, correctly applied the law that was applicable at the time that Mr. Jones was sentenced. Harris says that less legible serial numbers qualify under that guideline, and even if the amendment has changed that, again, the amendment was not effective, it's not retroactive, so even if it's something that the district court could fix, if this case were remanded for some other reason, it's not a legal error that this court should correct on its own. And turning to the gun trafficking enhancement, I would remind this court that that's a...
Staying on the serial numbers for
Sure.
a moment, do you agree that if Jones was sentenced today, it would not be proper to apply that enhancement?
That's correct. Under the facts of this case, I believe that there were some serial numbers that were just readable because they were able to trace them, but not necessarily like it would have been coming from the factory on a brand new gun.
And your opposing counsel submitted a 28-J letter that said that we should consider these intervening changes in the sentencing guidelines in this case because it's a direct appeal. You didn't respond to that letter. I'm curious what your response is to that argument.
So, Your Honor, just talking about how this court addresses those, I think this circuit's precedent is pretty clear that it only fixes them if it's some kind of like clarifying change to the amendment. But this one, under...
What case are you relying on for that proposition?
That comes from United States v. Goins, which is 357 F. 3rd 469. It's a case from 2004 that was decided in this circuit, and it basically says that for substantive changes that aren't retroactive, that's not something that this court is going to fix on appeal. And it also makes pretty clear that a change is substantive if it conflicts with prior precedent. A change in the guidelines is substantive if it conflicts with prior precedent. And of course, I think I can safely concede that the Amendment 828 to the guidelines does conflict with Harris and what it says about whether less legible serial numbers qualify for this obliterated serial number enhancement. If
So
that,
Harris would no longer be binding if the individual were sentenced today.
that's correct.
But what you're saying is that we can't consider this intervening change even on direct appeal.
Correct.
Or we can't apply the intervening change on direct appeal.
Correct, because it's a substantive change. That's not retroactive. If there are no further questions about that, I'll turn to the gun trafficking enhancement. And to the point that I believe you raised earlier, Judge Quattlebaum, if the gun trafficking enhancement is going to apply in any case, why not this one? I mean, this is a very clear example of gun trafficking in its most harmful way. And there's plenty of evidence in this case that the defendant was trafficking guns from West Virginia to Philadelphia. You know, they'd get them in Beckley, they'd take them up to Philadelphia. The district court, in finding the enhancement, focused on a particular set of transfers. As Ms. Toma mentioned, it was the transfers that happened at the end of September of 2020 is what the district court principally relied on. And the testimony was that they took some guns, they had come to Philadelphia, the guns were purchased by Bickford and perhaps others on September 26th or 28th, and then shortly after that, around the 28th, they went to a hotel room in Philadelphia, sold them in bulk for $16,000. Abdullah testified that they sold 8 guns. I think that Woodard may have testified that there were about 10. So the actual number wasn't clear, but to a point that was made earlier while Ms. Toma was up here, it's reasonable to assume, since they say, you know, the testimony is, we're buying these for $400, we're selling them for $1,500. The math just works out to where there's a $16,000 sale, that there is multiple guns associated. And again, the testimony that there were 8 guns, there were 10 guns, supports that. And I think it wasn't clear error for the district court to think that that transaction involved the sale of multiple guns to a particular buyer, because you have a group like the defendant and his co-conspirators who are agreeing to do this. There are about 4 of them. You have them, and like the defendant is kind of their guy. He's supplying all the money for them to be able to do this. They're getting a cut of the profit. And going up to Philadelphia, I mean, it's reasonable to assume that they're all meeting together in this hotel room, and the people they're selling them to are sort of involved in the same way. It's not that far-fetched, and again, the standard of review is clear error on this. It's not that far-fetched to think that that particular transaction and the way that it was set up involved the sale of multiple guns to a single person. So you have him receiving multiple guns in Beckley when he gets them, and then you have him transferring multiple guns up there when they're transacting them.
And we don't have the precise number of buyers in the hotel room. What do we have about that? I mean, I hear your point that we don't have to have precision on clear error, but what do we have about the buyers?
Your Honor, I don't believe that there is particular testimony. You're correct about how many there were, but the testimony does reflect that there were multiple people that they met. Like
Am I remembering right, like a handful or a group? I mean, was there some description besides just plural?
Your Honor, I don't recall right off the
Okay.
top of my head, but I believe that's correct, that it was a testimony that it was multiple people, that there were multiple people in this group that they were selling to, but there were no specifics about, you know, this one guy took the money or whatever. That did not come out at trial. That's correct. And I think this court should not flat out adopt the Henry and Daniels approach to this, because it does away with people like Judge Quattlebaum mentioned, who are buying an extreme number of guns. He used the number of 20,000. It eliminates those people just because they might happen to sell to 20,000 different people. But again, going back to the plain meaning of gun trafficking, that is gun trafficking. And it might not come up now because the language of this has changed and gone to as the guidelines currently stand, the firearm trafficking enhancement is not described necessarily in the application notes. It's actually in the body of the guideline. So it may be a moot point anyway. But I personally just think that it's silly in light of the rules that deal with multiple sales of firearms and how those are recorded. I mean, you can buy,
One reason, I point out the example that might suggest some silliness, but the response might be, look, you're going to get convicted on that. That's drug trafficking in the sense of, an offense. But if you're going to have an enhancement for the thing you were convicted of, it should be something different from that.
Your Honor, I believe that is correct in the sense that everybody's conduct, so this guideline is meant to apply to all types of gun charges, as Your Honor is aware. So you've got, felons in possession who they're convicted of that, but they maybe weren't trafficking them, so they won't apply. So it's meant, when the facts are egregious like they are in this case, to increase that liability because of the specific factors around the defendant's conduct. I mean, the the evidence that came out at trial is that he's got no regard for what he's doing. It's a profit.
It sounds like you're saying he's a bad guy, we should do it.
Your Honor, I'm not saying that, but I am saying, kind of going back to my original point about this enhancement, is if it doesn't apply in this case, what case does it apply in? Because this is gun trafficking by anyone's definition. What this group of people was doing is gun trafficking as normal people would understand the word. And to apply the guideline in a way that takes away from that and would not apply it in this case is essentially makes the guideline meaningless. And so that's the point that I'm trying to make. If there are no other questions about that particular guideline, I would like to address, before I sit down, the sufficiency of the evidence on count 2, which is the money laundering count. And the reason why I'd like to talk about that is because the defendant's brief focuses a lot, I think, on what I would qualify as the incorrect conspiracy. So really there are 2 conspiracies here as were charged in the indictment. There's the conspiracy to deal guns without a license, and that one involves the straw purchasers and all of that. But then there's also this conspiracy to launder money, and that's more about these 4 guys from Philadelphia who are the ones that are making they're the ones that are making the most money off of this. So again, this was charged as a conspiracy to launder money in promotion money laundering. And the substantive money laundering is proven by the evidence about how these transactions were working and the structure of this gun trafficking conspiracy. So the defendant is financing the straw purchases through Cash App, wire transfer, drugs, just plain cash, letting them keep leftovers. And he needs the straw purchasers because they're the ones who are giving him the ability to turn these guns around and go up there and sell them for a profit. He can't do that himself because he can't buy the guns. He can't get the guns legally from stores. So that's where the straw purchasers come in, but they are not themselves involved in the money laundering conspiracy. And
Have you gotten to the money laundering yet? Because you've gotten to the straw purchases, but tell me about the money laundering, because literally means to clean up money that has a nefarious or criminal origin, right? Or they're structured to basically say, well, you did this by hiding it, by making smaller type. Tell me what the money laundering aspect is.
so I would distinguish, Your Honor, respectfully between concealment money.
I'm not disagreeing with that. I'm just asking you to make it clear. I mean, just make it clear to me because you said, well, they're just cash apps and these people. Isn't it just like you do anything else with a bunch of criminals? I mean, allegedly. Well, no, they've been convicted, but the person says, okay, here's $500, go buy a gun, and they buy it. Is that money laundering?
So, Your Honor,
Let's take it by a little bite size rather than this big gulp. Is that money laundering? Did you say, here's $500, illegal, obviously. Here's $500, I want you to make a straw purchase of a 9mm. And then that person then sells that gun or gives it to someone else. Where's the money laundering?
Heaps would make clear that the mere paying a straw purchaser to purchase a gun is not necessarily money laundering in and of itself. And so that's
not at all, not necessarily, it's not.
So that's why I'm trying to make the point that this is a separate conspiracy that the straw purchasers aren't involved in. So you've got the testimony from Woodard and Abdullah in particular that this was a profit-driven venture that they were doing. You have the text messages that were...
Profit, that doesn't make it money laundering either. Okay, I'm getting money from it. Tell me the money laundering part.
So the defendant in this case is supplying all of the money for this venture.
Very well, right, understood.
But there was testimony from Abdullah and Woodard that he'd never had a job. There was the lack of records from the IRS saying that he had never filed tax returns from 2018 to 2021 during the time that this conspiracy was ongoing between September 2020 and July of 2021. And there was also information that we introduced in the form of summary records and bank records that he made about $65,000 in deposits into his bank between September 2020 and July of 2021. So
So that may, as I read the law, be evidence that he did this type of, I forget, there's two types of money laundering, that this type, maybe that's that he did, but your claim isn't money laundering, is it? Isn't the claim conspiracy?
That's
to money
correct.
launder? So if that does suffice for the defendant, what's the evidence that he agreed with others to money launder?
So that's where I think the text messages come through. So
Tell me what they say.
with regard to the particular transaction in September 2020 that I talked about earlier with respect to the gun trafficking enhancement, we introduced text messages between Woodard and Mr. Jones that Woodard is angry because out of that $16K transaction that they made, Woodard was supposed to get $3,000 of that, and he got none. And you know, the case law is pretty clear. They don't have to have an agreement that says, hey man, you want to launder money with me. So the fact that he was supposed to get a cut of that and that he knows that Mr. Jones is financing this, and we introduced photographs of them whenever they're down in Beckley. They're taking photographs at Sheets. They've got a big wad of cash that they're all passing around. And again, the fact that Woodard and Abdullah testified that this was a profit-driven scheme, that the reason why they were doing this is to make money, it's pretty obvious that Mr. Jones, who is the supplier of that money, is getting his money unlawfully. And
How is that obvious that he's getting it unlawfully?
because he doesn't have a job, he's depositing
Well,
all
he
this
has a-
money.
He has a rich uncle, for example. So you have to have a job to have money?
No, Your Honor, I don't believe you do, but
I
it
don't think
was,
so. You don't have to have a job to have money.
it was a reasonable inference for the jury to make that this
And
was,
why would, see, that's the thing, you take this to a jury, you know, it's like you throw it up on the wall, something's gonna stick. What basis or framework, how they're instructed to take that, say, well, you can assume that he must have, he didn't have a job, so he's a thief? He doesn't have a job because he's a money launderer? I mean, it's like the sense of overcharging it. Clearly, they were buying guns, working together to do that. But the money laundering part is very important because that's, you add that on. Then you make, I mean, you mean in the United States, the government, you add that on to the charge and say you conspired to launder money. And you don't have to commit any other substantive crime for that. That's why it's so ubiquitous. You got to be very careful about that. I just want to know what part of it, you told me they wanted to make money, yeah? You told me that, well, one was supposed to get this cut, but he didn't get it. That doesn't make it not allowed to make. They're a crook on top of a crook. I was supposed to give you half of it, but I'm not going to give you any of it. I'm going to give you a quarter of it. Where's the money laundering in that? All you've told me is that they were in cahoots to these straw purchases, and sometime he fell short in what their cut was. But that's not, is that money laundering? Oh, but then the other one is, he said they can assume he must have gotten that money from another person because he didn't have a job. That's the only thing you told the jury? That you can assume that because he didn't have a job, that made it conspiracy with them to launder money. Is that right?
two things that I would respond to that. First, Woodard was not a straw purchaser. He did recruit other straw purchasers, but he was the one who was supposed to get the $3,000 from that $16,000 transaction.
Right.
He's one of these money laundering co-conspirators because the point is that Mr. Jones is the one financing all of this. He's throwing his money into it. He has no job. He has no other source of income.
Aiding and abetting, they're partners in a crime. That doesn't make it a conspiracy to launder money. That's why I want to get to, that's different. What you told me is that he's a joint person. He's not a straw purchaser, but they're together and they're involved in this situation. But maybe it's a RICO. I don't know what it is in terms of, but money laundering is something different, isn't it?
So in this case, the purpose of the money laundering and why I mentioned the substantive offense and how it's structured with the firearms trafficking is because that's what's alleged in the indictment. That that the defendant wanted to promote money laundering wanted to promote firearms trafficking, and that was the purpose of the money laundering. So when you come back to, Your Honor, I see I'm about to run out of time. May I finish answering your question?
Yes.
Thank you. So the defendant's financing this, he has no legitimate source of income. Again, that was a reasonable inference for the jury to make, given the evidence that was introduced. Yet he's consistently putting money in this over a course of roughly 10 months, and they're making a profit on it that's just going back. They made another trip in October to go back and buy more guns. And I would submit, Your Honor, that given all that evidence, for the incredibly favorable standard given the jury's verdict, that these were reasonable offenses that could be made from the evidence. And, Your Honors, if I may just wrap up, if there are no further questions, the United States would ask that you affirm the defendant's conviction and sentence.
Okay, thank you, counsel.
Thank you.
Ms. Tola? Counsel went into an area you didn't touch on, so.
Yeah, I have a point I'd like to make in response to that.
Yeah, exactly.
Which is that at J 1272 PSR paragraph 94, the PSR states that Mr. Jones had worked under the table jobs, clearing property and cleaning houses. And so there's we're not here to dispute that he has some money from unlawful activities, but I think that the idea that none of his money was from anything lawful is just simply, there's some support in the record that that's not true.
But that's not the standard. In terms of, I mean, to me, there's a difference. It's important to think about money laundering, and there's importance to think about conspiracy to launder money. I think Judge Gregory makes his questions illustrate an important part, that just trafficking is not, and getting money for it is not laundering.
Right, and
But using money to put it back into the scheme may not be the way we think of kind of mafia money laundering, but is definitionally money
Promotional,
laundering.
yes.
And so that, and the evidence of money without a legitimate source, there's law that says that can, that can be evidence. So, there's one thing, maybe there's evidence that Jones money laundered, but the charge is conspiring to money launder. And I think that's the harder question is, did he agree with someone to do all that? I mean, your colleague pointed to some of that. What's your position? I mean, you can talk, maybe I'm wrong on all that, so respond to whatever, but that's the one I'm particularly interested in.
I would like to, I would point the court to, there's, I believe it was Mr. Woodard, one of his co-conspirators in the gun trafficking conspiracy, testified that he needed the reason, and my opposing counsel brought that up, that he was mad that he didn't get the proceeds from that sale, the $16,000 sale. And the reason he was mad about it, he testified, was because he needed that money to pay his bills. He couldn't pay his bills. He needed money to, he said, I don't have money to buy my son food. And so here's where the problem is that that's not an agreement to put money back into gun trafficking. That's I want my cut so I can take care of my business. And under heaps, like that's the sort of thing that is not promotional money laundering. It is paying your life expenses. And also the heaps cites a case called Jackson from, I believe, the Seventh Circuit, which said the same thing. It excluded from that money to pay bills and pay rent. So I'm not sure they've got any sort of evidence about an agreement with someone else to put this back into the guns. These people all want their cuts so they can take care of their own personal expenses.
Does it though? I mean, I think that, I appreciate that argument, but is it fair to look at the fact that the same four individuals are going back and forth to West Virginia multiple times, coming back with guns, selling them, getting a profit, and continuing to do the same thing multiple times over and over? Does that not allow the jury to infer that the money they are getting from the profit of sales are going back to the next time they purchased the guns?
I think, again, the distinction matters. I think it's definitely a conspiracy to traffic guns, but I don't think there's any evidence that they are taking their cuts or this money and putting it back in. I think they all very selfishly want their own cut to, again, put it towards their own expenses. I don't think there's an agreement to use that money to put it back in.
But
I mean,
they
it's
got
coming
to
them.
buy the guns, they got to buy the guns some way or another when they go back down there.
That
So-
money was all coming from Jones, though. It wasn't coming from anyone else.
Yeah, I hear you.
So,
Aye.
I do have a couple other points I'd like to very quickly make before I run out of time. My co-counsel brought up Goins, and I would just simply point out the distinction I made earlier is still relevant here because Goins was, I believe, a 3582C2 case. And so it's a different posture. This is, this is a direct appeal. And so Goins is not exactly on point. I would also note that in terms of the money laundering conspiracy, that actually is important because vacator of that count would affect the sentence, unlike the guidelines issues. The district court ran those consecutive, and so it absolutely would affect the sentence. And regarding the harmlessness, I also want to add that the district court did give Mr. Jones, even though he stacked the sentences consecutively in order to reach a certain amount, he still did vary downward a little bit on the sentence overall from the guidelines. And so I think had the district court realized that it was incorrectly believing that 4 to 8 points were, properly warranted for Mr. Jones, I think it could and would have gone lower. I see I'm out of time, so unless there are further questions, I would ask the court to vacate and reverse, please.
Thank you, Ms. Toma. I note that you are, even though you work as a federal defender, that you were assigned to this case, and I want to, on behalf of the court, thank you for that. We appreciate lawyers like you and others who help us in these cases, and thank you so much. And obviously, I note Ms. Shamlin's able representation of the United States. We'll come down, Greek counsel, and proceed to our final case for the morning.
Thank you, Your Honor.
Wait, I'm giving counsel a chance to put his things away.
Sorry about that.
Mr. Metlitsky.
Thank you, Your Honor. Anton Metlitsky for Illinois Union. May it please the court. The policies under which plaintiffs seek coverage from Illinois Union through a direct action include arbitration provisions requiring, quote, any dispute, controversy, or claim arising out of or relating to this policy, which undoubtedly covers this action, to be arbitrated in London. When a case like this one is subject to arbitration, Section 3 of the Federal Arbitration Act requires district courts to enter a stay. There is no discretion in that regard. Yet the district court here denied Illinois Union the chance to even file a motion seeking a stay on the ground that it would be inefficient in the context of an MDL for a party to move for an FAA stay without the consent of the MDL's lead counsel, who in this case denied Illinois Union consent. That cannot be right.
Counsel, can I ask a preliminary question that I don't think either side mentioned? The actual order that's being appealed is an order denying leave of court to file a motion to stay?
That's
Is that right?
Yes.
Do we have appellate jurisdiction over an order denying leave of court?
Yes, Your Honor, because I think the cases from all over the country make clear that orders that have the effect of denying a stay fall under Section 16. And
Like
this obviously, yeah, because otherwise a district court could just say, no one is allowed to file motions to compel arbitration or motions to stay pending arbitration, then no one could do anything about it.
So I don't, there may be lots of cases around, I think there are a handful of circuits. I don't think there's a Fourth Circuit one, but you're your argument is that this is the functional equivalent of a denial of a stay, and we should treat it that way, and that should give us jurisdiction.
Right, there is no Fourth Circuit case that I'm aware of. There's no controversy on the point, I don't think.
Okay.
I don't see how the rule could be otherwise. If the rule were otherwise, the court would have mandamus authority, because, you know, if it doesn't have either one of those, then the district court could just prevent people from.
Well, you could, in theory, you know, incur the ire of the district court by filing a motion to stay without leave of court, but that seems, that's your point, that's what.
Yeah, exactly, right. That's exactly the point. And then the district court could, in that case, strike the motion, in which case the order would be a motion, you know, like an order striking the motion, and we'd be in the same spot.
Okay.
So I think what we have is an order that in effect denied a motion to stay under Section 3 of the FAA. And I think the question basically is, can a district court in the MDL context, outside the MDL context, you know, for purposes of running litigation efficiently, prevent parties from filing those kinds of motions? I think the answer is no to that generally. Forgetting even about the arbitration context, there are cases, for example, the opioid litigation. Judge Kethledge has a lengthy opinion on this in the Sixth Circuit. He explains that multi-district litigation is not consolidation. It is a bunch of individual actions that are litigated together for efficiency purposes, but they don't lose their individual character. And so district courts can do all sorts of things to streamline the litigation, but the one thing they can't do is prevent parties in individual cases from seeking relief that they're authorized to seek under the federal rules or a fortiori under a federal statute like the FAA. And that's exactly what happened here.
Have you encountered this problem, this issue before in the MDL context?
I've not encountered the problem with respect to arbitration. I've just never seen a case like that.
It seems like it's a place where the FAA comes to meet MDL, and what do you do?
Well, so I think, I think this is actually an a fortiori case for us, because the general rule is that if you have a right to file a motion under the federal rules of, like, for example, a motion to dismiss, a district court can't tell you that you're not allowed to file it in an individual MDL case. The district court can put in time limits and meet and confer requirements and all sorts of stuff like that. But if you...
Should that motion go back to the original district court, or should it stay with the MDL?
Well, so that's within the district court's, it's not exactly within the district court's discretion. It's within the district court's discretion to ask the MDL panel to send it back to the transferor court. So if there are issues in individual cases that have been transferred to a multi-district litigation, and it turns out that those individual issues really aren't common, they're strange, they're sort of different than what the district court is dealing with, the district court can ask the MDL panel to send it back. Now, I don't see why you would do that in this case, because I think the underlying substance of the motion for a stay is very simple. But like the primary question here is whether the district court can just say, I'm not allowing you to file this motion. And I think it's very clear to that the answer is no. And just to finish the answer to your question, Judge Berner, I think the FAA context makes it a fortiori, because as the Supreme Court has held over and over and over again, the FAA does not yield to other statutes unless there's some clear statement in those other statutes that would make it yield. And so certainly it wouldn't yield to the MDL provision, which is not a substantive provision at all. It just is a provision for efficient litigation, but the MDL provision doesn't purport to take away any rights at all from a party, certainly not the right to arbitrate.
I think the question is whether the Wisconsin direct action statute somehow reverse preempts the FAA. I'm
So-
not suggesting that I think it does. I think that that's the
Right.
question, and that's not really a question for the MDL court.
Well, so I think there are two questions presented on appeal. I think that's the second one. Once you have decided that we should be allowed to make this motion, which I think is a pretty easy question, then the question is, what happens? Like, do we win the motion, right? And then I think the answer to that question is yes. There is no plausible argument, I think, for McCarran-Ferguson reverse preemption.
The district court, we could deal with that, or
Yes.
we could ask the district court to deal with that in the first instance.
That's right. That's right. I'm just saying that
Right.
it doesn't seem like a very hard question to me because, as we cited in our briefs, Wisconsin allows arbitration of insurance disputes, and the direct action provision, all that does is it allows a plaintiff to essentially step into the shoes of the policyholder. But I don't know of any jurisdiction that doesn't follow the general equitable estoppel rule that this court recognized in an international paper, which is when you're trying to get the benefits of the contract, you also have to live with the contract's obligations. So it would just make no sense.
So it sounds like you're not, I mean, we got, I guess, the district court first ruled that you didn't seek the lead, the consent for the
Right.
lead counsel and said something to the effect that alone is a basis to deny the motion. It then goes on to acknowledge that the request came later and then says it's inefficient.
Right.
Do you, it doesn't sound like you have any qualm that in the MDL there can be procedural requirements like seeking consent from parties and things like that. In other words, the deal of, well, they're adverse to me doesn't let you avoid procedural requirements. I mean, that may make sense kind of intuitively, but
Right.
the district court's entitled to put those sort of restrictions on when and how you do something. You agree with that?
I agree with that. I mean, as we explained to the district court below in our motion, we didn't think that that rule applied in this case for several reasons, including because of the adversity. We have no qualms with rules that, efficiency rules, including meet and confer rules and things like that, so long as the rules don't have the effect of preventing parties from making motions that are allowed to
If
make.
it stopped after the first kind of acknowledgement that you didn't do it and it was being hyper strict with the requirements and said, now you can do it and you do it right, that's all, that'd be fine.
Yeah, we would just refile our motion. The problem is what the district court said after that, which made clear that if we
That's
did
really why
refile the
you're
motion,
here, right?
yeah, the motion was denied. There was an alternative ground, and that ground can't be fixed by filing another motion because we're never going to get consent. So, that's really the end of it. And as Your Honor said, now the next question is, does the court the court can decide the arbitration case question itself? And I would just pitch that the reason to do that is because, of course, there's direct appeal. So if it goes back, I think it's a very easy question. There's no reverse preemption here. And if the court doesn't decide that, that's fine. We'll make our motion below, but then the district court will either grant the motion or it'll deny the motion. We'll be right back up here because there's a direct appeal under the FAA. So that's basically our position. If the court has further questions, happy to answer them. Otherwise, I'll reserve the remainder. Thank you, Your
Thank you,
Honor.
counsel. Mr. Cronin?
Good afternoon. May it please the court. My name is Andrew Croner. I represent the appellees, City of Wazoo and the Bouvet plaintiffs. And plaintiffs here request that this court dismiss the present appeal for two reasons. The first reason is that the MDL court's denial of Illinois Union's motion for leave was a valid exercise of its case management discretion. And the second reason is that the only issue that is properly before this court on appeal is the MDL court's ruling denying that motion for leave. It is not the merits of the motion to stay, which the MDL court has not taken up, that the parties have not briefed, and that it has not ruled on. Focusing first on the MDL court's ruling denying Illinois Union's motion for leave to file, it is certainly within, as I think counsel acknowledged, the MDL court's broad case management discretion to impose and enforce a duty to consult with lead counsel before filing a motion for leave with the court. Again, counsel, I believe, conceded that, imposing meet and confer requirements before filing a motion is a valid exercise of that discretion, and that's effectively what CMO 2A is. It's a meet and confer requirement, just not with opposing counsel. In this instance, with lead counsel for your side. And I do want to correct one thing that counsel said, which is, this idea that that defense co-lead counsel necessarily has adverse interest to Illinois Union. Defense co-lead counsel represents all of the defendants in the MDL, not just the manufacturer defendants. There are different subgroups, and there is a manufacturer defendant subgroup. But Illinois Union is not unique in that it's a party on the defense side that may have interests that don't necessarily align with the manufacturers. The U.S. government is among the defendants and has to ask and consult with defense co-lead counsel when it wants to file motions. And so here, further, the requirement in CMO 2A to consult with lead counsel is appropriate because it allows lead counsel.
I'm not trying to be rude here. I mean, he's basically saying that, I thought he said that doesn't have a issue with the fact that there's those sort of requirements. I mean, he seemed to be arguing for something he's conceded, unless I'm missing something.
Well, I don't think he's conceded that it was proper for the court to deny the motion for leave here.
On the second basis, yeah.
Which is this idea that it would be sort of an inevitability that the court would never.
He's saying the thing about meet and confer, is not something he's really here for. He's here for the second part of the district court's order where the district court says, I know he's done it subsequently and I'm still denying leave because it's going to be inefficient. So I'm not going to allow you to make your motion.
Well, I don't think we know that for certain, for one thing. For another, this goes back to, the MDL court's inherent authority to control when and how a motion is brought to bear. This is not, the MDL court is tasked with addressing issues that are common to, more than just one case or two cases, within the MDL. That is the MDL's focus, and then those individual case-specific issues, that's when you remand back to the transferor courts to address those. And so I think it was, and part of the reason why I think the MDL court relies on or imposes this duty to consult is that, lead counsel is also tasked with ensuring that what is addressed in the MDL are these common issues, that is the focus of the proceedings, and not on, while the cases don't lose their individual character for purposes of the pretrial proceedings that happen in an MDL court, the focus is on these common issues and, one-off, issues that apply in just, to one defendant in two cases, it may not be a priority for the MDL court to address that.
Well, it may not, but, I mean, the district court seems to say that because lead counsel doesn't agree, aside whether you complied with it technically, because the lead counsel didn't agree, you don't get to make the motions. And these MDLs, apparently there's some, you're precluded from doing that.
I do think that the MDL court places a lot of weight into lead counsel's decision about whether or not to approve or not approve a motion, but I think the entire reason for the motion for leave mechanism is that if lead counsel does not want to sign on to a motion, the court still wants to hear it, to hear reasons why it should allow the filing of that motion. So I don't think it's necessarily true that, that lead counsel's refusal to approve a motion necessarily means that it's not going to be able to be filed. And I do think also.
So you don't think maybe I'm just missing something. I'm confused. Is it your view that this is all preliminary, that they could go, file their motion for a stay, and we got the cart before the horse here? That I mean, and you don't think the effect of the district court's order prevents them from moving to stay?
I think it may prevent them from moving for a stay right now. I don't think it prevents them from moving for a stay indefinitely. I mean, there's 17,000 cases in this MDL. A lot of them present threshold issues that have to be put on the back burner so that the court can choose which issues to prioritize. And I'll give one example. The first common issue that the court in this MDL prioritized was the government contractor defense. And that required a lot of third-party discovery by the United States government. Now, the United States government wanted to file a number of jurisdictional motions that presented threshold issues, and the court said, no, we need you to hold off on that so that we can do this discovery to address the government contractor defense, because that is an issue that is, common to most of the cases in the MDL, and is really the type of issue that the MDL court is supposed to focus on in the first instance. And so, really, and the idea of the mandatory nature of the stay, I mean, that only kicks in once the court determines that the issue is subject to arbitration. And there's been no determination by the MDL court that that's true. So,
So if there was some ruling that made it clear that they were not going to get to file their motion to stay, as the act seems to give them, would you agree that would be improper?
No, I wouldn't, because I don't think that it gives them a absolute right to file a motion to stay. What it does is say, what Section 3 says is, if a court determines that an issue is subject to arbitration, then it has to impose a stay.
Well, how's a defendant who's got an arbitration clause, what are they supposed to do? They say, I got an arbitration clause, nothing in the MDL statute says you lose it. They're trying to move for a stay, and it looks like they're not being allowed to do that. Now, if the argument is, okay, this is just some timing thing, they're going to get to do it later, I mean, maybe that's an issue, maybe that's what you're saying, but I'm trying to figure out if effectively they're not going to be allowed to file their motion for stay and they're going to lose it, that would violate the statute. Do you agree with that?
Well, I think if there was a universal prohibition against even seeking a stay, yeah, I think that would be the case, but I don't think that's what we have here. I think we have, like you said, an issue of timing.
He didn't say that, though. I mean, maybe that's right. Maybe the order just isn't flushed out enough and we don't know. I mean, he says lead counsel doesn't consent, MDLs involve a whole bunch of balls in there. I get that. I actually have some understanding of that. But it doesn't indicate, the time's coming for that. And I'm setting this in order. As I read it, it's kind of the lead counsel's failure to consent means you don't get to file the motion. Am I wrong there?
I mean, I think the court can rely on lead counsel's, decision about whether to approve a motion in deciding whether or not to grant a motion for leave. I don't think that it's necessarily guaranteed that just because lead counsel is not going to approve a motion that that the court is somehow bound to then not allow them to file it.
But that's what they did here, right?
That's what they did here, but I think there are good grounds for that, which is, again, I think CMO 2A was put in place to prevent, motions that were filed for individual cases amongst these 17,000 that were not addressing issues that were common to, either well, there's no issues that apply to the whole docket, but at least a large portion of the docket, these issues, again, that are common to a lot of the cases that the MDL court is tasked with resolving before it sends the cases back to the transferor courts to deal with the case-specific and individual issues. And so, I think lead counsel, I think the MDL court, lead counsel's approval refusal to approve that here is partly based on the fact that it knows that the MDL court does not want, 150 motions individual motions to stay to get filed by different parties who feel like they have a right to arbitration. What it wants, and part of the reason for the duty to consult, is if someone brings a motion to lead counsel, they have a duty, if that, motion is going to apply to other cases, to file it all as one consolidated motion for efficiency purposes. I think that duty also entails if, the lead counsel recognizes that this is a singular issue in one case, that it's not, it is not a good use of the court and the party's resources to, bring that issue to bear when there are still a number of issues that cut across a large number of cases that the court needs to address.
Do you think the MDL regulatory scheme usurps the Federal Arbitration Act?
No, I do not believe that, Your Honor.
It doesn't, does it?
No.
And also, did the individuals have a chance to seek or proceed with arbitration before their cases were transferred to the MDL? In other words, say, no, wait a minute, I don't want my transfer. I want it right now. I want to be heard on arbitration, FAA. Did they have that obligation? Or was it just sort of fiat? You go there.
I'm sorry, I don't know if I understand your
What I'm
Honor's
saying is,
question.
before they were transferred to MDL in that process, that scheme, did they have an opportunity to assert their rights under the Federal Arbitration Act before that was done? Or did they have to all go in that batch you talked about? That's an easy question.
It's they would have, because, these cases were filed originally in state court, and then they got removed to federal court by the defendants.
Right.
And then they were transferred to the MDL
They
thereafter.
were transferred, right? Didn't hear was there opportunity to assert those rights? Arbitration? Arbitration is a matter of time in terms of, if you don't do it on a timely basis, you basically have, well, I'll wait until the jury's, in other words, is impaneled, or do I wait till a verdict and then you can get it changed by arbitration? Time is of the essence, right? Isn't it the essence of arbitration?
But I think the timing matters to the extent, I just want to be clear, it's not as though the MDL court is forcing Illinois Union or any of these other insurers to litigate their claims. The cases are, like many in this MDL, sitting there sort of waiting for this order of priority with how the court's going to address the issues to play out. So, this is not depriving them of arbitration by forcing them to litigate these issues in the MDL. It's just saying, we're not going to take up your motion, we're not going to take up the arbitration issue and the state issue at this time.
It may be years later, right?
It could be.
Right,
This MDL has been going on for quite a long time, and
That's
so.
that's why I say it could be
Yes, Your
years,
Honor.
more years. So, so de facto is usurping the FAA, if not legally, isn't it?
Well, I don't think it's preventing them from ever getting this, or ever seeking to vindicate their arbitration right in perpetuity.
But if you have a right, and Congress has given you this right, and you're trying to exercise it, and it seems like you're saying, we're not eliminating that right. Just sit tight. You're going to get to do it. And you're 8 years later, and you're paying lawyers and doing all this stuff to be part of this process that takes forever. It just seems like you're rendering what a mandatory obligation from Congress to be almost nothing.
Well, again, Your Honor, I would disagree that it's a mandatory obligation, particularly in this case, because again, the stays only becomes mandatory once the court
But you're not
determines.
letting him establish it. You're saying there's a condition to staying, that it's subject to arbitration. That would be resolved wouldn't it, with that's bound up in the motion to stay.
It's bound up in the motion to stay in the sense that.
So you're
the
saying
court-
there's a preliminary issue, but you're not letting them, present the preliminary issue?
At this time,
I got you.
you know, and so, and I do think that this, you know, I disagree with counsel that I do think that there is a you know, strong possibility that there is reverse preemption here. You know, counsel mentioned that Wisconsin law favors enforcing arbitration provisions in insurance contracts. I do not think that that is true. What it does, the policy in Wisconsin is to favor arbitration provisions that are approved by the insurance commissioner. And this provision at issue in this insurance policy was not approved by the insurance commissioner. I also think that the direct action statute itself, the purpose of that, as far as the Wisconsin insurance framework, is to provide a forum for those injured by the negligence of an insured of a general liability policy, a forum to actually litigate, you know, the coverage and to seek, you know, recovery in litigation in court, and not to go to necessarily to arbitration. I mean, we did, you know, reference the Evans case, where the Eastern District of Louisiana found that a similar direct action statute that was adopted in Louisiana reverse preempted the FAA and the arbitration provision in that case. And, you know, at the very least, you know, again, I don't think we're really there as far as like addressing the merits of the motion, because the parties have not briefed, you know, the actual motion to stay. The court has not ruled on any motion to stay. But I do think that at least leaves open the possibility that it is not as clear cut as counsel would like to suggest, that, you know, that just the existence of this arbitration provision in the policy, it conclusively shows that this needs to go to arbitration. I think that is still something that is in dispute. And, you know, again, I think it is within the MDL court's case management discretion to say, okay, this is an issue that I'm going to need to address, that the parties will have to brief, that is going to require an investment of time, but it only applies to one defendant in 2 cases. And I have a docket of over 17,000 cases that I'm trying to, you know, get to a point where I can start remanding cases to deal with these types of individual issues. So I you know, again, while, you know, I think that the proper, frankly, the proper recourse here would have been for them to refile. And, you know, I know your honors may say, well, if they don't get the consent of co-lead counsel, you know, it's likely that the MDL court will deny that motion for leave. And, you know, that's probably fair, but we don't know, you know, for sure what's going to happen absent the procedural defect, you know, where they didn't actually consult lead counsel in the first instance before they filed their motion for leave. You know, and so I think to ask this court to effectively, you know, make a ruling on the motion to stay when that motion hasn't even been filed yet in the district court, I don't think that would be, you know, is the proper relief here. And for that reason, that's why we think that the appeal should be dismissed, and you know, Illinois Union should refile, this time in full compliance with CMO 2A. And, you know, if the motion for leave gets denied, you know, to me, then you may be in the, you know, this is effectively a denial of the stay territory. I don't think we're there yet because of the procedural defect in the first instance that, you know, that they didn't consult with the co-lead counsel before filing their motion for leave.
Thank you. Thank you, counsel. Mr. Cronin. Ms. Matlitsky.
Thank you, Your Honor. Just a few points. First of all, on the last point that we don't know what the district court would say if we refiled, we do know because the district court said so.
Yes, I was thinking too, we only had the first part, but we got the second part.
Exactly. On the point that there's been no determination, so no stay is warranted, of course, the reason there's been no determination is because we weren't allowed to file our motion. On the point, the concession, I think, is that what the order does is prevent us from moving for a stay now. Maybe we'll be able to do it a few years from now or something like that. But the whole point of the Federal Arbitration Act is we have agreed that we don't have to be in court. We get to arbitrate this issue. They're the ones that sued us in a direct action under this policy. This policy has an arbitration agreement. The Federal Arbitration Act gives us the right now to go to arbitration and
So
get a stay from the court.
Let me ask you something there. Let's, the order doesn't say this, it just says, you know, without lead counsel's
Right.
approval, you know, it's inefficient. I mean, if there was an order, or if the district court had said, you know, I'm gonna hold that motion, you know, we gotta do this first, then that, then this, and so there's a sequencing of events that we do have to manage. I know that's not ideal for you, but I'm getting to it, you know, in this time or another. Is there anything wrong with that?
So I think there might not be anything wrong with that with respect to some motions that you're allowed to file. I think there is something wrong with that with respect to a motion to stay pending arbitration, because the whole right is not to be stuck in court, right? That is the right under the Federal Arbitration Act. If you have been, if you have agreed to arbitrate, if you have an arbitration agreement, the
But if
reason.
they stayed any proceedings against you, so you aren't part of discovery, you're just in a holding pattern, you know, while the court works through some of these things.
Well, a stay is what we were asking for, so
Yeah,
if you gave us a stay, then great. But without a stay, I mean, they served discovery on us, I believe. So the idea that we don't have to litigate, I'm not sure what that means. I mean, we
Right.
have an individual action, we are in court, we have the right to be in arbitration. It's sort of the end of the matter. Just quickly on this point that lead, I'm not sure this even matters, but the idea that lead counsel represents us, I don't know whether that's true in the aggregate or whatever, but when the question is coverage, lead counsel can't possibly represent us and our policyholder. Like, that's impossible, right? And that's what's going on here. What's being arbitrated, what should be arbitrated, is coverage. And then just on the merits. So real quick, approval by the insurance commissioner for arbitration provisions, as we point out in footnote 1 of our reply brief, that's not right. That does not apply to policies like this one that were negotiated outside of Wisconsin. And there is nothing in the direct action provision that suggests that the direct action has to be in court. And that would be utterly bizarre given Wisconsin's general rule that insurance claims can be arbitrated, because if that were true, it would mean that in a direct action, the non-policyholder would have greater rights than the policyholder. That can't possibly be right, because the direct action is just you're stepping into the shoes of the policyholder provision. So I think this court can decide the question on the merits, but at the very least, the court should issue an order requiring the district court to allow us to file our stay motion.
Thank you, counsel.
Thank you.
I'm going to ask the clerk to adjourn the court until